So I think that we can start. Good afternoon. Welcome to this Meijers Committee webinar on the state of the rule of law in the European Union. My name is Morijn, and I have the great privilege of chairing this panel. In a previous life, I was a civil servant in the Netherlands, and I worked on issues like privacy and EU human rights. And there was this one NGO that often sent well-timed, comprehensive, to-the-point letters and studies to politicians that put fingers on weak spots, formulated sharp questions, and suggested alternatives that sounded to me as a civil servant eminently reasonable, and did indeed often frequently end up in speaking notes of parliamentarians. That was the Meijers Committee. That is a group of independent academics, judges, attorneys, and NGO workers that has as its mission to ensure that the arc of binding European Union law, migration law, and criminal law bends towards justice. That is still the mission, and I'm very glad to now be actually a part of that committee and to help continue the rich tradition of constructively speaking law to power. We are here today to discuss specifically the challenges of the rule of law in the European Union member states and at the EU level, not in an academic fashion or as a theoretical measure, but as a Meijers Committee, we are after action and traction. We want to understand better the nature of the rule of law backsliding, and we want to engage in an effort to isolate backsliding and help roll it back so that the situation on the ground gets to become more in line with the binding EU law. To channel our efforts, we just started a project dedicated to this issue that will run for 3 years. You can find out more on the website that is easy to remember, euruleoflaw.eu. That is euruleoflaw.eu. Today is the kickoff of what we hope can be a contribution from the Meijers Committee that makes a difference. Now, to assess where we need to go, in what way, and who we should work with, we first, of course, need to know precisely where we currently are, how we ended up here, and whether something has so far been done to counteract constructively and that has actually resonated. And to do that, I'm truly delighted to have 3 real experts with us. I each admire very much and learn from every day. Let me introduce them to you in turn. Márta Pardavi is co-chair of the Hungarian Helsinki Committee. She has received many awards, prizes, and recognitions for her work, such as being on the Politico's list of the 28 most influential people in 2019. But in fact, we, outside and inside Hungary, are the real winners of all of her efforts and that of her team. Because of their work, we know what is going on, and more particularly what is going wrong in Hungary. With its strategic litigation and very comprehensive and incisive policy briefs, the Helsinki Committee has an impressive track record of making an impact in the real world. For me, the NGO Márta helps lead is the gold standard of human rights NGOs. And currently, Márta is on an academic sabbatical in the city where I myself did my PhD, Florence. So I have to say I'm extremely jealous of her and her current proximity to pistachio ice cream. Our second speaker is Anna Wójcik. Anna is a scholar and a journalist in Warsaw. She seems to have more hours in her day than most of us. Apart from being inches away from defending her PhD, she has for some years now been the contributing author to the Poland chapter of the influential Freedom House Nations in Transit report. She helped set up a most useful resource on the Polish rule of law situation, ruleoflaw.pl. And as a journalist, she writes, and I should admiringly add, writes very well for the independent investigative newspaper oko.press about many aspects of interest to us. So well that Oko Press, like many other outlets that help us understand what's actually going on in Poland, is often sued in so-called SLAP cases, strategic litigation against public participation. Anna is therefore extremely well placed to give us a good understanding of developments in Poland, including with regard to news media. Then finally, Lane Scheppele she's a professor of sociology and international affairs at Princeton University. And I have to say, she truly is a one-of-a-kind scholar. She has been working and writing on backsliding in Europe for more than 10 years. And that timeline alone underscores her track record of seeing things coming early, much earlier than most of us. Professor Scheppele has co-written standard works in the field that you should all read, such as the 2017 article Illiberalism Within with Professor Laurent Persch, and the recent article EU Values Are Law After All with Dimitri Korchinov and Barbara Grabowska-Moros. My personal favorite, however, is her 2013 article Rule of Law and the Franken-State. She argues that what is true for the law generally is true for the rule of law particularly, that there is little point in only looking at the letter of the law if you don't take account the overarching spirit, and that characterizes and that what characterizes autocrats is a completely instrumental power-based view of the law. For autocrats, law is disconnected from a spirit linked to achieving justice for all. That article changed my own perspective quite a lot, and as the great Dutch philosopher Johan Cruyff once put it, you only start seeing things once you grasp them. I should also mention it's 6:30 in the morning for her, so we're particularly grateful, Cam, that you're here with us. So I think that all of you, and there's some 100 people listening in, will agree that we have gathered quite a stellar panel here to kickstart our Meijers Committee project. And I think you will also agree that any second I myself talk here, as is often the case with guys on a panel, is a waste of time. So I will wrap up and make space for the real experts. I have asked each of them to speak for about 10 to 15 minutes, but I plan to be generous because it's almost weekend and it's sunny outside. After that, after they have given their perspectives, I will open the floor. All of you tuned in, you can ask questions through the Q&A function of the Zoom session. And these questions will then end up with me, and I will try to do justice to both their letter and their spirit. We will wrap up at around 2:30, and the event, as you see, is being recorded, so it can also be watched back later. So that's it for me. Thank you very much again for accepting our invitation, and I'm glad to give the floor to you, Márta.
Thank you very much, John. Thank you very much for both the invitation and the wonderfully nice words that you spoke about the Hungarian Helsinki Committee. In fact, we are very proud of our achievements in our work, but it would not really be possible without the work of people both in and beyond Hungary. And I think this this gathering and this event also demonstrates the importance of this. It's not only enough that rule of law has become a crucial topic that is basically always on the agenda now in Europe and in discussions even beyond Europe, but it's also equally important that there are individuals who dedicate their professional and also private time to this tirelessly. And it's great to see that more actors, more individuals are coming on board in defense of the rule of law. It's I think, a great initiative from the Meijers Committee to create a website and to offer the various tools to help us find our way through the increasingly labyrinthic measures and initiatives. I also very much admire the work of Kim and her colleagues, and also all my Polish human rights defender friends in Poland and outside. I have gotten to know a lot of them over the past few years, and it's really both incredible to see the similarities and also the differences, and to know that there is such a strong community and a strong friendship between Polish and human rights defenders and rule of law defenders. So it's great to be in your company. Now, when I got the task of talking about the latest rule of law developments in Hungary, I mean, it's a big task, right? Like, how much do we want to talk about? There is a lot of things that have happened in the past year. So what I will talk about will inherently be faulty. I have to put this disclaimer out there. It's not going to be an all-encompassing and detailed listing of the events, but there's been quite a lot written up also by the Hungarian Helsinki Committee and other human rights organizations. And also, of course, the rule of law monitoring report of the European Commission itself, with all its imperfections, is still an important basis and a sort of a launch pad for any discussion. when I was thinking about what to talk about with these disclaimers, I decided to focus first on the architecture. What kind of architecture do we have within Hungary to protect the rule of law? Is there anything left? Is there everything in place? The opinions differ. Now, we've seen, however, that this is an ongoing battle. It's not done. It's not a done deal. But certainly the last year, and probably this year too, with COVID, has afforded an opportunity for autocrats everywhere in the world to seize power, to exploit, to conceal, to use the pandemic and related emergency measures to also grab power in places which are not connected at all to a public health emergency or the economic emergency that accompanies it. And this is, of course, true for Hungary too. But some of the most important developments that have been that have also been on the agenda, the top priority agenda of 2020, have been around forever. And we see a gradual regression and a gradual backsliding or just a destruction, dismantling of a constitutional architecture in Hungary. This continued, of course, in 2020. I'll first focus on the independence of the judiciary, as this is always a key topic when we talk about the rule of law. And as I think many of the audience's members will also recall, there's been several attempts since 2010 to erode judicial independence in Hungary, but there were also many failed attempts, and I think we have to recall these too. There was, of course, similarities with the Polish government steps, but there is, I think, also differences in the approach. First, the approach was really a lawnmower approach, mandatory retirement of lowering the mandatory retirement of the age of judges. This was found to be against EU law. So here already the Court of Justice stepped in with a different set of arguments. And of course, the outcome, whether full judicial independence in this sense was restored, that is certainly did not happen, but it was a failed attempt. And I think it also instilled in the judiciary itself heightened awareness of the threats that it was facing. And so we did continue to see, and still today, a lot of judges taking very sound and professionally based decisions, focusing on the law and on their job, their mission as those who are upholding legal rules. So in face of this sort of less visible resistance, but professional resistance and ethos, the Hungarian government continued on its course. And many will recall the attempt to set up a new public administrative court system, which would have yielded probably a very pliant, very friendly judges and jurisprudence, friendly to the government, to government agencies in many important issues, ranging from elections to public procurement, taxations, many civil liberties issues. This also failed. It had to be retracted. The plan was actually dropped by the Hungarian government. There was quite an outrage over the idea. So now what we saw in 2019 and 20 was actually a more legalistic, more piece-by-piece approach, a top-down approach that is, I think, meant to trickle down over time and permeate jurisprudence and judges' careers and personal matters in a less immediate way. So some of these measures were introduced in 2019 in December, an omnibus bill that covered a lot of changes to judicial issues, and also later on in 2020 and beyond the legislative measures, there were personal decisions taken that are relevant in this respect. Without going into the details, and there's quite a lot written up about this, but I will just mention that I think the realization that drove these measures was that it might be enough to slowly and in a more subtle way capture an entire judicial system by putting in place at the very top of the justice system individuals who will be loyal, who will not cause trouble, but rather assist the government in achieving its mission. Individuals who actually are maybe not very committed to the idea of checks and balances and judicial oversight of government decisions, but rather perceive the role of the judiciary as a friend, or perhaps even a servant of the executive power. We have seen how this has happened in the Constitutional Court in Hungary, which has rendered that court as a very friendly, very understanding, and not too bothersome institution. The National Judicial Office, which was mired in personnel scandals, there's been welcome change at the top, but this change has resulted in this has changed the personnel change. The new president of the National Judicial Office has not actually remedied the structural deficiencies of the office. And also a recent report by Amnesty International Hungary pointed out how judges still do not feel comfortable and in fact experience a chilling effect when it comes to voicing their opinions, their fears, and their critical remarks. There are exceptions, but this, I think, in contrast to Poland, given the more subtle measures, has also resulted in an easier way to tamper judges' otherwise critical remarks. Legal changes have elevated the role of the Constitutional Court and the Supreme Court, which in Hungarian is called Kuria. State bodies can now turn to the Constitutional Court against decisions that were taken in public administrative matters that might be uncomfortable, and hence out of the ordinary court system, certain cases can be shifted to a more politically understanding judicial body, the Constitutional Court. Conversely, Constitutional Court justices can become ordinary judges and will automatically be transferred to the Supreme Court, the Kuria, once their tenure ends at the Constitutional Court. This revolving doors, basically, in a way, allows for more for influencing jurisprudence from the very top. And of course, the most important development that took effect on January 1st of this year is that the Kuria, the Supreme Court, has a new Chief Justice. Justice Varga is somebody who has not had a very long track record of being a judge. Instead, he was very much allied to the chief prosecutor in Hungary. Some say he was parachuted into this role, despite, of course, the very manifest protest of the National Judicial Council, where there was overwhelming rejection of him being appointed to this post. But nevertheless, the Hungarian Parliament, with the requisite government majority, appointed him for a tenure of 9 years. Now, the office holders' powers are also expanding and will have more influence on who judges will be, which cases they will be looking at, adjudicating, and how jurisprudence in general will evolve. So as I said, the trickle-down slower effect is evidenced in this web of measures. The new Chief Justice has very strong opinions, personal and professional opinions on all matters constitutional or rule of law, and he's voiced these opinions quite widely. We have made a compilation of these statements, and they do not bode well for rule of law protection in Hungary. Just to pick a few, he has talked about the judiciary as the most dangerous branch of government. It has grown over the political branches, he said. The interpretation of the rule of law within the EU has become tyrannical, moreover, totalitarian, and it has become, no one will find this surprising given the Hungarian government's consistent statements. And he has also repeated that it has become the instrument of arbitrary exercise of power. So I think this is certainly a development to watch. We will have to see what this will mean in practice in terms of judges, in terms of cases, jurisprudence, case allocations, and all these measures. But it is certainly something that should receive a lot of attention. Now, the Hungarian ombudsperson, in contrast to Adam Bodnar in Polish, is not a particularly strong figure when it comes to rule of law and human rights protections. There is a new ombudsperson in place. Our research has shown that this new ombudsperson has not been very active in certain areas, but active in others. The ones where he is active is generally those that are not politically sensitive. But when it comes to crucial issues about human rights and rule of law, he's been pretty silent. Therefore, we really question whether he and the office performs the role that it should be performing under the principles that apply to national human rights institutions. Also important to note that the equality body, which had been a separate institution in Hungary, has been subsumed under the ombudsperson's office. There was not much in terms of explaining why this change was necessary, but we certainly see it as potentially contributing to weakening human rights protection. The media, big topic, and certainly one that is extremely important because media would have, in addition to civil society, an extremely crucial role in upholding rule of law. They are pillars of the rule of law. Now, the latest, just to highlight, have meant that the #1 independent online news portal has, during the summer index, has basically been emptied out of journalists who all stood up and formed a new website because they feared, rightfully, extreme political influence given the new ownership of the media outlet. Klub Radio, which is a radio station, certainly with a very strong government critical approach, has had its license terminated, and it's now applying for a new radio frequency license. The Media Council is delaying a decision on this. The Media Council has over time become a completely, fully Fidesz appointed body. Its impartiality is really, really missing. And in this sense, we see its new action, the latest of yesterday, where it launched a procedure against Hungary's largest cable private commercial television station, RTL Klub, the German-owned RTL, which had aired a social media campaign video from Háttér, an LGBTQ rights organization. And the Media Council has decided to launch an investigation saying that this is actually a child protection issue. Now, this both shows how a Media Council has become a complete tool of government initiatives, direction, but also I think shows how, and this leads me to a new theme, new topic, the LGBTQ community is becoming under attack in Hungary. We've seen this roll out over a number of measures. And I think yesterday, Mr. Orbán's Samizdat blog post, which is interestingly published on the Prime Minister's website. So the title of this media outlet is really, I think, outrageously disrespectful of political dissidents everywhere who have to publish in Samizdat, but that's just a personal remark. So he, in reacting to the decision of the Fidesz group in the European Parliament to leave the EPP group, has actually made it very clear that his new political agenda will include fueled hate propaganda against gay people. Now, these measures that the government has taken are met with quite a lot of public dissent, but when television stations have to face potential consequences, fines, or others by the media authority for giving a voice not only to dissent, but to the idea that LGBTQ people also have rights and are equal, this does not bode well. So what can they do? What can Hungarians do to protest these measures when November has meant a legal change that outlaws public protest? There is a complete ban in effect on public protest in Hungary. And this is absolutely, of course, done under the guise of COVID. I will now switch very quickly to the main issue. And this is where my sort of recommendations come in also. What we should watch, closely monitor, and maybe concentrate is on the legal issues. The Hungarian government does all these under the facade of legality. It's extremely important for the government to maintain this facade, but we have to look beyond it and to pull that drape and expose what there is. And we do have tools for that. The Court of Justice of the European Union has rendered several extremely important decisions in 2020. Just to name a few, the one on the transit zones, detention, the Lex CEU, Central European University judgment, the Lex NGO case on the transparency of civil society organizations funding, and also on pushback legislation that also falls in the asylum realm. None of these important judgments, which really drive to the core of many of the rule of law issues in Hungary and fundamental rights issues, none of them have been implemented. So what can we lawyers, citizens do? I think we have to call for the European Commission to use its powers, and it has done so on the Lex NGO case, where it has actually triggered, after informal dialogue, a formal infringement process again. But when it comes to asylum cases, I think we might see more hesitation. Asylum is such a politically divisive, polarizing topic, and Mr. Orban exploits that to its fullest extent. It's good that the Meijers Committee has this migration portfolio too, because you will, of course, understand how closely rule of law is tied to this issue. Now, Hungarian asylum policy has really become the testing ground to see how long an EU member state can get away with flaunting, with disregarding court judgments. And particularly in the pushback legislation case, which is a result of an infringement procedure and culminated in a judgment in December, we've seen how the Hungarian government has continued the policy that the EU court has found to be unlawful to this very day, and has basically meant that since the mid-December judgment up to today, about 10,000 people have been pushed across the border in what has been established to be absolutely against EU law. The Commission should, I think, knows what's happening. Even Frontex has decided to suspend its operations in Hungary over this after many years of basically just standing by and not doing anything against this unlawful practice. So now when an EU agency has actually decided to pull out of Hungary because of this flagrant disregard for a Court of Justice judgment, I wonder when the Commission will take action. And if it does, it might actually lead to a new infringement procedure under Article 260. And in the meantime, there's so many other infringement actions and also preliminary reference procedures pending at the Court of Justice on asylum that we might in a few months or in 2021 come to a situation where we might not have a perfect storm, but we will certainly have a storm, a flurry of cases reaching the court, all focusing on the inherently inhumane, but also anti-rule of law asylum policy. So we cannot discount a scenario where the parallel cases would need to be looked at in a more comprehensive manner and addressed in this comprehensive manner that cuts to the core by the European Commission. And I think this is something that Kim might also talk about, but this would be my main recommendation, and then in the discussion, maybe a few more that I would just put out there. Thank you so much for listening, and I look forward to the discussion.
Thank you so much, Márta, for this very comprehensive overview. We see many parallels, I think, with what Anna will tell us, but what will be an interesting point of comparison later on is also where there are the subtle differences, and whether some of the things that may have worked well to push back against this in Hungary could, for example, also be applied in Poland. That's the type of the things that we want to focus on. Before I give the floor to Anna, I can have some latest news, which also gives a bit of a sense of the speed with which rule of law developments take place. As you may know, together with some other academics, I have closely followed what happened to our colleague Wójcik. Just an hour ago, or half an hour ago, he was cleared by a court in Warsaw. So it's really important. I think that's also a good way to introduce Anna, that it's not a black and white issue at all in Poland. There's many actually very courageous and independent and impartial judges in Poland, and just like in Hungary, they just deal with people who are not judges at the very top. So it's actually extremely courageous that a judge will just find in accordance with the law. But at least some good news for Friday, and we'll hear much more from Anna. Thank you.
Thank you for your lovely interaction, and thank you, Márta, for your presentation about Hungary. People in Poland are watching what is happening in Hungary very closely. The government, but also people who are against government policies and the opposition. So we are all rooting for the elections and for the change of heart of the public opinion and electorate in Hungary next year. So, of course, Polish government, since almost 6 years, wants to emulate Hungarian government in its rule of law policy, but also it outpaced it and outnumbered many changes in this regard. So I would like to stress that the rule of law crisis in Poland is only getting worse, and it only accelerates. And actually the events of the past week has demonstrated that there are still so many new cleavages and issues that we need to focus on. So first and foremost, in the past week, we had a judgment of the Court of Justice of the EU that was a big boost of confidence for judges in Poland, because it gave them a solid legal basis to evaluate changes into the Act of the National Council of Judiciary, and it provided the Supreme Administrative Court opportunity to actually rule that those changes were not in line with the EU law. And this is really important because these days the burden of the rule of law fight in Poland is really on judges, on prosecutors, on independent media, on human rights defenders, on attorneys at law, which are actually withholding the pressure and are taking very courageous actions. But it is not that all the disciplinary proceedings, all this legal architecture that the law and justice has been implementing is not is in place, and it has an effect, a chilling effect on many judges. So on one hand, we are very optimistic that perhaps the Supreme Administrative Court may rule using the EU Court of Justice judgment, but on the other hand, we should bear in mind that after Judge Paweł Juszczyszyn was suspended more than a year ago for applying a judgment of 19 November 2019, not many judges in Poland followed in his steps, especially after the muzzle law, the law that makes disciplinary responsibility for judges even harsher, entered into force. So we see that despite the fact that the EU Court of Justice is expected to rule in one EU law infringement case and in several cases arising from preliminary reference questions posed by Polish courts, we still we will see whether judges in Poland will actually remain brave and how they will apply the law. But on the flip side, in the recent days, we've seen two very brave judgments from judges in Poland. The Court of Appeals in Warsaw ruled that the order of the disciplinary chamber in the Supreme Court against Judge Igor Tuleya was not valid, and it ruled that Igor Tuleya is still a judge in the context of the preliminary reference questions he asked after he was suspended. And the other good example, a ray of hope, was a very mediatized, politicized case regarding the freedom of expression of activists who prepared stickers with a sign of a religious icon, modified that it includes the rainbow colors, the halo in the LGBTQ flag colors. And luckily, the judge in the court of first instance acquitted the activists. And this was a really important case in Poland because the opponents were a Catholic priest who actually was involved in a smear campaign against LGBT people, and a very prominent anti-abortion activist. So immediately after the ruling was announced, state and pro-government private media, they started a campaign against a judge who ruled in the case, scrutinizing her personal life, her career. So this really demonstrates the level of pressure and the level of bravery, personal bravery, that the judges in Poland must now have to actually rule according to law. So getting back to the National the Supreme Administrative Court, actually the process of capturing the Supreme Administrative Court and the Supreme Court is ongoing, and it only accelerates. We have recently seen many promotions of associates of the powerful Justice Minister Zbigniew Ziobro. The most important of them is promoting Ms. Anna Dalkowska, who is Deputy Justice Minister, to the Supreme Administrative Court. Ms. Dalkowska was representing the Polish government in many cases at the EU Court of Justice, and she actually replaced as Deputy Justice Minister Mr. Piebiak, who was involved in a scandal regarding the allegedly coordinated campaign against the judges in Poland. So we see that her nomination to the Supreme Administrative Court is a sign that there are more and more judges who are supportive of Mr. Ziobro there. Furthermore, there is an even bigger issue regarding the Supreme Court. Since last May, there is a new president of the Supreme Court. Quite surprisingly, Ms. Małgorzata Gersdorf, who was a staunch defender of the rule of law, was allowed to continue her mission until the termination of the mandate in April. And then Ms. Manowska was decided to be the first president. And actually, for almost a year, she was quite silent on many issues, but now we see that she's been supportive of the government's agenda. Recently, the President of the Republic proposed a draft law on the Supreme Court that increases the competences of the first President of the Supreme Court, but also of the President of the Republic. So the President of the Republic will be able to nominate the so-called commissioners in the chambers of the Supreme Court. There are 5 chambers, 3 of them are the old chambers, 2 of them are the new ones that are filled with people who were selected in the procedure involving this unconstitutional National Council of Judiciary. So in a couple of months, the presidents of the civil law and the labor law chambers will retire, and that it opens a possibility to replace them with the so-called commissioners. And actually, judges in those chambers asked many preliminary reference questions to the EU Court of Justice. So we see that this is one important issue. Another one is that this draft law actually gives more power to the president of the Supreme Court, Ms. Manowska, to actually decide, allocate cases in the court. The bill was adopted on the 25th of February by the lower house, by Sejm in Poland, and we will see whether it will become law, but it is highly likely. Then we also have the question of the Constitutional Court. Many people in Poland realized last October the level of politicization of this court and how it impacts on their everyday life and their rights. I'm of course alluding to the infamous judgment regarding the restriction of the abortion law. But the court is also very friendly to the governing majority. Its president, Julia Przyłębska, she has recently commented on this EU Court of Justice judgment from 2nd March, that she finds that the EU Court of Justice overstepped its competences and the treaties. And Ms. Przyłębska will soon decide a case that will be probably brought by Prime Minister Morawiecki. Prime Minister Morawiecki wants to challenge the EU Court of Justice judgment. It was announced by his spokesperson that the Prime Minister will submit a motion to the Constitutional Tribunal for a comprehensive resolution of the issue of conflict of laws between the European law and the Constitution, and for the confirmation of existing case law in this respect. We haven't seen the motion yet, so I cannot tell you about the details. But the governing coalition politicians, including Sebastian Kaleta, the Deputy Justice Minister, imply that the Polish city is no less than the German Constitutional Tribunal, and they all the time refer to the German court's famous ruling of 5 March last year regarding the EU Central Bank. So we see that this situation in the Constitutional Tribunal is very friendly to the governing majority. And another highly political case that will be decided soon regards actually Adam Bodnar, the Commissioner for Human Rights. His term officially expired last September, and he still continues his mission because there is a provision in the Act on the Commissioner for Human Rights that demands that the former commissioner continues his job until the new one is appointed. And the procedure demands that the lower house and the upper house agree on the candidate. And so far, the candidate that was supported by Lane Justice was rejected by the Senate, that is controlled by the opposition. So Adam Bodnar is still working as the Commissioner for Human Rights. However, the group of Lane Justice MPs brought a motion to the Constitutional Tribunal to verify whether this provision that allows for that is constitutional. So we will see on 10th of March if there will be a hearing in this case. Adam Bodnar demanded that Ms. Julia Przyłębska is excluded from the panel, but we don't know if it will be accepted. So of course, we are in this difficult situation right now in Poland, perhaps the most decisive since the beginning of the COVID pandemic. That will accelerate probably the rule of law backsliding in Poland in a significant way, because in 2015, 2020, we had at least some key institutions that were important actors in the rule of law fight in Poland. These were the Supreme Court, the Commissioner for Human Rights, and also independent judges and prosecutors. And now we see that the Commissioner for Human Rights, well, it will be captured probably by someone who is maybe not from the Law and Justice, but at least someone who Law and Justice agrees on. And then we see that the Supreme Court will be soon tilted towards the governing majority. And in this context, it is highly consequential what happens with the independent media in Poland. Because the framing of the rule of law fight in the pro-government and state media, which were turned to be a propaganda machine, is that judges are defending their privileges and they are old communist agents or persons who are not qualified to rule because they don't rule with the sense of like social responsibility. So it is actually instrumental to have some independent media and NGOs active in various fields, in the human rights field or in the rule of law field, that would actually tell a different story. And the problem is that, as you may be well aware of, the state company Orlen has bought majority, almost all local press in Poland. And it also controls, the government also controls public broadcaster, which is heavily subsidized by the state. And there were plans to introduce a tax under the guise of having some contributions to fight with COVID, to tax advertising incomes of media publishers. This was disproportionately affect private publishers, which are critical of government, and would allow those smaller outlets that are pro-government not to be included. Media in Poland staged like unprecedented protests against the planned measures, but we don't know if it will become policy or not, and it will see in the coming months. So definitely there is a synergy between the workings of civil society, and by that I mean also the workings of judges, prosecutors, attorneys, and human rights defenders, and independent media. So there are some independent media initiatives that are successful, as Oko Press, which is supported by donations from readers. And this really gives us a real independence from corporate and from state influence. But of course, we have limited outreach, and there is a need to support new initiatives that can blossom and support public opinion that does not feel comfortable with the current governing majority. But there is also a growing sense of disillusionment and disenchantment with the EU institutions, especially the European Commission, among people who care about the rule of law in Poland. Because even reporting on the letters sent by Vice President Jourova and Commissioner Reinders is actually quite it's quite difficult, because people are upset and they see that the EU is not doing as much as they would expect to. The EU Commission repeatedly says that it will monitor the situation in Poland, but we are well aware what's happening in the country. And we are very pleased to hear that the Commission understands some of those issues, but we would like to see that it acts more forcefully. Also, it is very much welcomed by the rule of law defenders that the member states of other countries, and especially the Netherlands, are active in the rule of law defense. And it is really important that the member states' governments join proceedings at the EU Court of Justice. This is something that provides arguments, because those member states are more outspoken, actually well prepared, or can say more than the EU Commission says. So this is something that really gives a lot of confidence to judges and prosecutors in Poland. And I would also highlight the need of creating new funding possibilities or cooperation between civil society organizations and media in Poland and in other member states, including the Netherlands. And I will maybe follow up on some of those issues during the discussion.
Thank you so much, Anna. And you're forgiven for the noise that is being made by your upstairs neighbors. Nobody heard it. We were all completely focused on what you had to say. What I found very interesting is this new development. Márta was earlier already making the point that if there's European Court of Justice rulings there, at the moment they're ignored in Hungary, even in Poland. It's not only that, but you actually try to use the own court system that is being captured to sort of question the validity of European Union law in the first place. That's an interesting contrast, hopefully not a complementary development at some point. I wanted to ask you, is it still the case that there's also going to be a specific challenge in a Polish court with regard to the rule of law conditionality regulation? Is that still the plan, or was that just something that was tabled but not pushed forward?
Well, aside from the case at the EU Court of Justice, it has not yet been challenged by courts in Poland, because it is not tribunal.
Thank you very much. Thank you. We look forward to hearing from the other side of the ocean in the very morning in the US. So the floor is yours, Kim.
Great, thanks so much. And I'm really delighted to be here because you've heard about the two rogue states of the European Union. But one reason why I'm really delighted to be part of this Meijers Commission forum is that there has been one state that's really stood out for its defense of the rule of law, and that is the Netherlands. And so what I want to say today is something about, the Netherlands' role so far, what a very good member state could do to try to help this problem, and why the EU institutions have been so slow to respond and so ineffective in really containing what's been happening. Seen from a kind of, very tall level, Hungary and Poland are not just a collection of individual sort of infringements, so to speak, or a collection of particular problems. And I think Márta and Anna made very clear, these are concerted campaigns by an elected government to shut down the division of powers, checks on executive powers, and any institution that might be independent that would check what's happening in these places. It's not a coincidence that the judiciary and the media and the civil sector are particular targets, because those are places from which serious challenges could come to these regimes. Seen from on high, if you look at how the international sort of ratings agencies, so to speak, for democracies have looked at this, Freedom House demoted Hungary from free to partly free 5 years ago by now, and in the last year has now ranked Hungary as not really a democracy. The Varieties of Democracy Project, which is really where political scientists use all of their tools to try to figure out how to classify regimes, has now classified Hungary as a competitive authoritarian regime, which is to say no longer a democracy. Hungary is about 5 years ahead of Poland. Poland is on that same trajectory. So Poland has moved from being a free to partly free country under the Freedom House classification. And it's also falling precipitously in the Varieties of Democracy Index. Hungary is, I think, by now a totally captured country, which is to say, I am not at all confident that free and fair elections are either possible or likely to actually get rid of this government in power. And while Poland still has, I think, a much more lively opposition, in the sense that there still are opposition political parties that could probably govern and might get elected under the current election laws, that window too is closing. So I just want to emphasize the severity of this seen together. Okay, now the EU relies on, you read Article 2 of the treaties, and the EU relies on the EU being a union of democracies. It assumes that countries are democratic, following the rule of law, respecting human rights as they come in the door. And one of the real dilemmas with the EU is that it never imagined, in the course of constructing the treaties and constructing the institutions, that there would ever be countries certified as rule of law-based human rights respecting democracies that once they got in the door would have the problems that we now see in Hungary and Poland. Let me just call out why I think the Netherlands has been just so good in this process all the way along. From when Viktor Orban was elected, this was his second time, actually in 2010, but his first time governing without true constraining coalition partners. The first embassy in Hungary to recognize the problem was the Dutch embassy. I want to shout out to Bert van den Linden, who was a member of the Foreign Service, who was deputy chief of mission, fluent in Hungarian. He'd lived in Budapest in the 1980s. He had a wide collection of Hungarian ties, and he was the first one to recognize in the foreign diplomatic community how serious this was. And the Dutch embassy, as early as 2011, formed something they called the Transparency Group of rule of law democracies that were consulting at diplomatic level in Hungary and trying to figure out how to respond. And that was a Dutch-led initiative. I might say that this continued because when Frans Timmermans was foreign minister of the Netherlands, he also tried to organize his fellow foreign ministers to think about how to cut funds to member states that were abusing their position in the EU. He didn't have as much success as he might have, but the effort clearly came from The Hague. And this was before Frans Timmermans then became vice president of the European Commission, where he had the portfolio for rule of law and really was extremely active in the very early days of the Polish slide out of judicial independence. The Commission actually invoked Article 7 very quickly. It brought very aggressive infringement actions as long as Frans Timmermans was there. The current Commission has not kept up that level of, shall we say, engagement. Over at the European Parliament, again, the Dutch delegation has just been terrific. So Judith Sargentini's report was the one that triggered Article 7, which is the corrective mechanism for democracy seen as a whole. Judith Sargentini's report triggered Article 7.1 against Hungary in 2018. Sophia Intveld has also been very active on this, one of the most active members of the European Parliament in pushing rule of law agendas wherever she can. And, you know, I might say that just the Dutch government also has now been a leader in two other ways. One was the Dutch Parliament's call for the government to actually get together with other friendly member states and think about bringing in action before the Court of Justice under Article 259 of the treaties, about which I'll say more later. In addition, the Dutch national courts have actually started with some very powerful judgments saying, with regard to the European arrest warrant, but it may spread to other areas, that the Polish judiciary is simply not reliably independent enough to send someone back to Poland for prosecution. In addition, finally, I might just say that the Dutch government has really led the way during those complex negotiations from last summer through December over the new multi-annual financial framework. And the Dutch government was sort of one of the leaders in insisting that the rule of law conditionality regulation, which is now called the conditionality regulation because rule of law kind of got demoted in the process, unfortunately. But that was really, that would not have survived in the state that it has if it weren't really for the actions of the Dutch government. So let me just say that the Netherlands has really been one of the leaders in trying to preserve and protect the rule of law. And I'm going to say it can do even more, of course, because of course, no good deed goes unpunished. And it seems to me that because we still see, as Márta and Anna said, that there is such, I wouldn't even call it backsliding. There's a concerted assault on both democracy and the rule of law, and of course also human rights in these countries, that more is needed. So let me just remind everybody of the structure of the European Union. This may sound like it's going back to real basics, but at times like this, I think it's really crucial that we think about that. The European Union, you know, as Jacques Delors famously said, is an unidentified political object, right? Which is to say, it has a structure unlike any other international, transnational organization. The EU is neither a federation, nor is it a common international organization. And the main way in which the EU deviates from other forms of international organization is that by signing on to the EU, a member state both agrees to a mechanism through which further laws are made, sometimes without its consent, right? Which is to say it can oppose an EU law and nonetheless it is bound by it. So this is a very unusual feature of international organizations. But also within the EU, member states give up what is often seen in most other international organizations as their right of self-help. which is to say that in joining the EU, member states assume that the EU institutions will actually police whether the law is made properly and followed adequately in the member states. And the member states have largely given up their ability to just retaliate one-on-one against other member states of the EU. Okay, so that's the basic structure. And in the EU, the Commission is designated as the guardian of the treaties. And the Commission has this power through bringing infringement actions to ensure that member states are following the rule of law. And you've heard from Márta and Anna that the Commission has brought these infringement actions against both Hungary and against Poland. But as you can also tell from Márta and Anna's presentation, those infringement actions have not yet been successful in really arresting the slide into a kind of non-rule of law state. Now, why is this? So some of it is because the way the Commission has brought these infringement actions is too narrow, too little, too late. So famously in the case that Márta described, where the Hungarian government lowered the retirement age of judges, that was a case where the Commission expedited the case. The Commission, really pushed the European Court of Justice. The Court of Justice responded with a bold decision that found Hungary in violation. The problem with that whole effort was that the first thing the Commission could think of as the legal basis for the claim was age discrimination. And the problem with age discrimination is that the remedy for discrimination cases is usually that those who have been discriminated against get compensation. What the Commission really needed to do was to think about how to reinstate the judges. And the Commission actually didn't have a leg to stand on to do that, especially when Viktor Orbán came back, and we can expect the Polish government to kind of echo some of Orbán's early successful arguments. Orbán said, well, what do you expect us to do? Fire all the new judges that we hired in a giant hurry because we saw this coming? And the compromise reached between the Commission and the Hungarian government was that the new judges would get extra protections, which is to say, not only did this backfire, right, which is that Orbán got rid of many of the leaders of the judiciary, but the Commission helped him install new judicial protections for the judges who owe their careers to Orbán, who will now be there for longer. Okay, so this is really not how the whole thing is supposed to work. And the Commission got smarter when it got to Poland and it looked at these attacks on the independence of the judiciary. Frankly, one of the best actors in the European system so far has been the Court of Justice, because the Court of Justice threw out a lifeline to the Commission and said, look, judicial independence is something every member state must guarantee for its own judiciary. And that emboldened the Commission to ground the Polish actions on the judiciary in this claim of judicial independence, which the ECJ has upheld and issued a number of very strong, very bold decisions. So what's the problem? The Commission has not been enforcing these judgments, as both Márta and Anna have said. The governments of Poland and Hungary have blatantly violated these judgments, have not enforced them, or have nominally honored the judgments that were handed down and then gone around behind them and done something else that has done exactly the same thing. Okay. So how can we think about this? So first of all, the Commission right now is just not active. It's just not bringing enough infringement actions. It's too slow, too little, too late, not following up on enforcement. There's a real lack of political will in this Commission, which is really unfortunate, and that's the hand we're dealt at the moment. So what can we think about doing? So this is where I want to revert to what I just said earlier about self-help. When the treaties were drafted, they didn't actually eliminate all of the mechanisms of self-help that were left to member states if the member states felt that some of their fellow member states were not, shall we say, with the program of democracy, human rights, and rule of law. What was left in the treaties as a mechanism of self-help is this Article 259 in the Treaty of the Functioning of the European Union. And it allows any member state to bring an action before the Court of Justice against any other member state. Now, I might say, I see that Dmitry Koshinov is here on the webinar, and he's the one who really generated these ideas, and he and I have worked together on all of this, but he's really the one who sort of figured this out, I think. Article 259 is one of those things that European lawyers laugh at, because if you look at the cases that the Court of Justice has actually decided under Article 59, they're all kind of losing cases. I won't go through all of them, but if you're just a lawyer doctrinally looking up Article 259, you'd think this is really not where you want to go. But here's the thing. If you look at the treaties, what Article 259 does is it says any member state can bring an action against any other member state, and the acting member state doesn't have to actually demonstrate that they themselves have been harmed by whatever violation it is in the member state they're complaining against, which is to say, it's a duplicate provision to the Commission's ability to bring a member state before the Court of Justice claiming rule of law violations. If the Commission's not acting, the member state or member states jointly can act in the same capacity. Now, what Article 259 says is that the member state or member states that are seeing massive rule of law violations in another state bring the action, and the action has to stop first at the Commission. And the Commission then can analyze this action, decide whether to join it, in which case it flips over to being a regular 258 infringement action, or the Commission can say, we're going to take a pass on this, and it goes forward to the Court of Justice as an Article 259 action. So one of the reasons why all these 259 actions look like such losers at the Court of Justice is because usually the Commission joins the meritorious actions, and you miss the fact, actually, that these things started as member state actions, right? So this is one way that rule of law committed member states, and I'm looking at you, the Netherlands, right, can actually spur the Commission to act, or embarrass the Commission, right, by bringing the action, and if the Commission doesn't join it, you can go ahead anyway. But this was exactly the remnant left of the self-help you normally find in international organizations as the EU was set up, and there was a concern, which unfortunately is a well-grounded concern, that the Commission may be too weak to enforce the rule of law in member states. And I think we're in that position now. I think Article 259 is kind of emerging as really one of the great hopes for member states to force the Commission's hand. And so this is where I was so heartened by the fact that the Dutch Parliament gave instructions to the Dutch Prime Minister to look around, find allies, which I think the Dutch government's in a good position to do, because it knows from all those negotiations over the multi-annual financial framework, who are the rule of law member states. There are reliably 4, 5, maybe 10 member states that have really gotten upset about this problem. And if the Dutch government could coordinate them, failing that, even going it alone, but I think, the Dutch government would have allies in this regard, can bring an infringement action against either Hungary or against Poland or against both for these rule of law violations that we've seen. Now, let me also suggest, before I close, that there are a couple of other things. So first, one thing on how to frame an Article 259 action. One thing I think we've seen, and you've heard it in Márta and Anna's presentations, is that the Commission has been absolutely legalistic and not in a good way in the way it's brought infringement actions, right? So it brings an infringement action against one tiny slice of a problem. And even when it wins, and again, the Court of Justice, I think, is on fire about this issue. The Court of Justice recognizes that if you don't have a union of democracies, if you don't have a union of rule of law member states, the EU itself is existentially challenged. The ECJ gets that. I think it's going to, if the cases can be brought to it, I think it will act. But the right kind of cases have to be brought. So I think that with regard to these rule of law issues, what's really crucial is to see the problem as a whole, right? The problem is not just that the Polish Council for the Judiciary has been compromised. It's that the Polish Council for the Judiciary has been compromised, and they've gone after the composition of the Constitutional Court, and they've gone after the leadership of the Supreme Court, and they've set up this disciplinary chamber so that any judge who refers a case to the Court of Justice, or any judge who runs afoul of the current government, can be disciplined. It's the set of things, and not just one together, that challenges the independence of the judiciary in Poland, right? So what an infringement action needs to do is to bundle those things together. They may be separate infringements, and you could take any one of those to the Court of Justice as a separate case. But it's the set of them, it's the collection of them that really makes this a particularly serious problem. And if you think about it, the treaties also give us ways to kind of tie this together. So one way to tie this together is through Article 4.3 of the Treaty of the European Union. That's the so-called loyalty principle, and it says that member states must engage in sincere cooperation, right, with the EU institutions in order to achieve the goals and purposes of the EU within each member state. Once you get a pattern of violations, it's not just a set of random problems, right? It's something that is a comprehensive rejection of the applicability of EU law in the member state. And Article 4.3 is kind of like a rope bundling these things together. And there's an elaborate jurisprudence of the Court of Justice about Article 4.3. That's something, again, I think the Court of Justice would be highly open to elaborating. And it's a way of saying that if this action succeeds at the Court of Justice, you have to think about, so what's the remedy for this? And if there's been a comprehensive violation of the independence of the judiciary consisting of all these elements, then the state will not be in compliance, the member state will not be in compliance with that judgment until it not only eliminates the individual violations, but restores the principle of sincere cooperation, right? Which is to say, if you bundle this under a bigger theory, it's harder to evade with legalistic workarounds. And that's where I really think that we need to go next. And so the Commission should have been doing this all along. Actually, under Frans Timmermans, they were really trying, shout out to Dutch leadership. The current Commission is not doing that. But our two rogue states, are still falling from grace, falling every year. There has to be a moment when this actually comes to a head, and the ECJ, and I think the rule of law respecting member states working as a team can provide a way around our Commission lacking political will, can also find a way around the Council, which has enough member states blocking or not caring about this thing to act on the Article 7 files that are open before it. I think that's going to be the way forward. So two last notes before I stop. One is that national judges have played a huge role in this. And again, the Dutch courts have been in the leadership on this. The Irish courts have come around. We're starting to see a number of different member state courts start to question the judicial independence of these rogue member states. And so far it's played out mostly on the European arrest warrant. But if this thing isn't stopped, I think national courts will stop honoring the judgments in other areas that the national judges in captured member states have been issuing, and that will really be the end of mutual trust as we know it. This is an existential crisis for the EU. National judges see that, and I think they're raising flags and flares, and I think that's an important element. And finally, I might say, and I think Márta and Anna are really two very good representatives for this, the people in these member states who are fighting to preserve EU values, democracy, the rule of law, and protection of fundamental rights need all the help they can get. They need the help not only just in terms of moral support, and I think hearing, and you can hear from Márta and Anna that neither Hungary nor Poland wants for extraordinary talent at trying to fight these things off, but it's a very difficult job. But the people who do this are under tremendous pressure at home. I think it's really important for civil sector organizations in the other member states to reach out and embrace and support and take in as partners the civil sector organizations in the challenged member states, so that anytime those organizations are threatened or harassed, that they get immediate support from a network of other Europeans. And I think that we're all in this together, and I think that the NGO civil sector in these challenged member states need all the help they can get from civil sector initiatives in other member states. So there's more to be said, but I think I'll stop there. And just to say that, I'm so delighted to do this before the Meijers Commission, because the Dutch have really been the leaders on this question since the very beginning, since 2010. And to keep up the leadership position, I think it's time to turbocharge the activity. I know you guys now have an election, but I hope as soon as the election's over, that the new parliament recommits to Article 259, because I think that's really an important thing for Europe. Thank you.
Thank you so much, Kim. I think that we have all learned from your talk that we should no longer talk about backsliding. We should ban that word, and we should simply call it what it is, a concerted assault, which also, like you say, immediately makes this link with the loyal cooperation and the disloyalty, in fact, of it. I already see some questions coming in, and I'm going to encourage a lot of others to do the same, ask a couple of questions. Before I go to these questions, I wanted to ask one thing from Márta and Anna, which is also something that's important to the Meijers Committee. You both mentioned issues with regard to LGBTI protection, both in Hungary and in Poland. What is unclear to us is whether this really goes back to a real ideology, or is this something that is just politically convenient to do something else behind that smokescreen of anger instead? How deep is that anger against LGBTI both in Hungary and Poland? And maybe that you can answer that, Márta and Anna, and then I'll gather a few questions and we do the next round.
Yeah, thank you. On this specific question, I must say that I'm not an expert, and there are wonderful experts out there on Hungary and Hungarian NGOs and informal groups and movements forming, fighting for equality. Yesterday, there was a hearing in the European Parliament. The LGBTI intergroup held a hearing, and there were a lot of wonderful people there. What I can say with maybe my lack of depth of knowledge is that in the case of Hungary, this is a new issue. Obviously, there is a public sentiment that has to be taken account of, and it can be exploited and abused and fueled. Same way with what happened in 2015 with refugees and migrants in Hungary. I think the Hungarian government has identified this particular issue as one that has been weaponized elsewhere, and is putting quite a lot of effort into boosting hate, with not as much success as it has had with stirring up xenophobia. But at the same time, of course, there is not a majority sentiment, but there is a sentiment that can be boosted. And if the propaganda media channels and senior government figures and also laws themselves convey this message, then of course that popular sentiment can be swayed, shifted. My colleagues have always said that in the last few years, one of the positive signs of progress was exactly on this field in Hungary, on acceptance. I think a lot of people just, this is not an issue that concerns them. But that this, plus the legal measures that maybe have been progressive in Central Europe, because you don't have registered civil partnership everywhere, that these were fragile measures in a fragile popular space. And so I think this is being undermined. But I think, and I really don't want to go into these sort of personal details, but with obviously a government which has and a political party which, of course, among its own members also has gay people, as we find everywhere. Turning this into a real thoroughbred ideology, I think, is not the case in Hungary.
In Poland, it's quite different, because I would say that the main goal is actually to use the specter of neo-Marxist gender and LGBT ideologies, that's a phrase, to scare some people and to manipulate people who are the audience of pro-government media. And actually in Poland, we also have the Catholic Church as an important factor. Even like years before Law and Justice was in power, when Donald Tusk party was in power, it was impossible, unfortunately, in Poland to pass legislation that would comply with European standards regarding protection from hate speech, and we don't have civil partnerships in Poland. So the attitudes of the Polish society were slowly changing. There was groundwork done by NGOs, and there were some attempts to fight with homophobia. So there were cases of MPs who were openly gay or transgender before the Law and Justice term in power. But of course, after the anti-migrant feeling, was not useful anymore to an extent in Poland, a new scapegoat was the LGBTQ community. And as often with racism or misogyny, people never say that they are racist or misogynist or homophobic. They only say that they are against an imposition of this new dangerous ideology that is, as President Duda said, worse than communist ideology taught in schools. And this reflects also this deep generational divide in public opinion in Poland concerning LGBT issues and the current government's policies. So, for example, among the younger demographic, most people think that what is lacking in Polish schools is sex education, and what the older generation is saying, that it lacks discipline. So you see here a clash of generations, a clash of attitudes, and this is really this really reflects on attitudes towards LGBT rights progression. But what is really a significant element of the rule of law backsliding and of this populist authoritarian party in power is that we don't see any progress on LGBT rights in Poland for more than 6 years now. So this is something that is also like in the public opinion's view is distancing Poland from other EU member states. But sorry for my neighbors again. But on the other hand, we see that this is a topic that is really important for younger generation, and that the current governing majority only stirs up to induce people to vote in crucial elections. So this was instrumentalized to actually get a couple of percent higher turnout from core constituencies during the last presidential elections. And after the elections were over, when President Duda won, the anti-LGBT campaign didn't stop, but it slowed down. So we see that this is an issue that was like artificially made to improve electoral outcomes.
Can I add something very quickly on this? I know we have more questions, but just very, very quickly. So in the 1990s, I spent most of that decade living in Hungary, and I was one of the founding co-directors of the Gender Studies department at Central European University. And I also had the great privilege and joy of being a researcher working at the Constitutional Court. In 1995, the Hungarian Constitutional Court issued the first ever judgment, I think anywhere in the world, but certainly in Europe, requiring the legislator to set up a parallel system of civil unions for same-sex couples. That was 1995. That was way ahead of the rest of Europe. The parliament, in response to that Constitutional Court decision, immediately changed the law, like no problem. And that law still exists. So registered civil unions are still permitted. They're still recognized in Hungary. And in fact, the government hasn't really taken any steps to roll that back. Now, the anti-LGBTQ rhetoric that now is in the Constitution as a result of this new constitutional amendment just a few months ago is very worrying. But in fact, it doesn't roll back protections that were already there. It will prevent new protections from being put into place. I might say that, one big difference between the Polish and the Hungarian governments is that Viktor Orban, claims Christian values. The guy has never really been very religious, and this is mostly cynical. In Poland, it's a Catholic country that really believes it, right? Which is to say that there's a difference insofar as anti-LGBTQ stuff is part and parcel of a particular vision of the Catholic Church. this is a sincerely held set of beliefs, and that's why I think Anna says that it's not just the current government, but prior governments that have also just been very difficult to enforce this. One last thing. Some of what these governments are doing is what I call distraction management. So when the Hungarian government put into this recent constitutional amendment, this anti-LGBTQ language prohibiting gay adoption, among other things, it was designed to focus everybody's attention on that provision away from the other things that were in that constitutional amendment, most crucially, a provision that actually allows a lot of EU money to pass completely out of the system of state audits. And had the LGBTQ thing not been there, the global attention might have focused on these other things, which was really where the government's agenda is. So what I tell people is, in Hungary at least, whenever LGBTQ stuff comes up, what it usually means is the government's doing something else you should be worried about. Not that LGBTQ stuff isn't vitally important, but it's often used as a kind of distraction because they know the EU will take the bait.
Márta, you want to react to that?
Yes, I think it's good that we spend so much on this issue, because not only is it something that I think is a grave human rights violation and a threat, but also it's going to be, I think, playing out on the political arena as a polarizing and divisive issue. Viktor Orban pointed to this. I think he is keen on garnering support for a new political formation or joining an existing one in the European Parliament. This will be the common ground. These will be their shared values, those that actually completely negate the European Union's shared values. And I wonder how that plays out when the Commission this year will also, roll out its LGBT equality strategy, which has specific measures proposed. One of them is actually a mutual recognition of parenthood. And the other is maybe to look at same gender partnerships and to support mutual recognition. Now, these are policy areas where the Hungarian government and the Polish and their political allies can join forces and further divide European public opinion. Even there's tons of money flowing into this from Poland or via Poland to Hungary to organizations that work on this. But at the same time, yes, it might be a divergence from other core issues, but this actually is making people leave these countries. This drives away young people who would want to start families. This is creating a new group of, I can say, yes, persecuted individuals from Poland and Hungary. And they can thankfully go to other EU member states and live their lives. But this means that they have to choose between, living where they would want to otherwise. So can we tolerate this? And I really would want the European Commission to push very strongly on a rights-based approach and an equality-based approach, and not be, put off. And I think we have to use legal tools to ensure that these rights, whatever is in place, is respected, and we promote this despite the political difficulties that might want to, have some member states maybe stay silent on this. This is not an issue that should be, covered in silence.
Yes, also, if I may have only
yes,
one
please, and then
remark.
we move to the question, please, Anna. Yeah.
Yes, I think that the international pressure also influences public discussions in Poland regarding LGBTQ rights. It was visible on the example of those resolutions promoting family values that are called the anti-LGBT resolutions. And actually, despite the fact that many municipalities in Poland adopted them, then it provoked a considerable discussion whether it is really something that should be in place. It's not a binding law, but it still influences the lives of people who live in those areas. And the public outcry in other countries, the question of withdrawing EU funds and Norway and EA funds from those towns was really something discussed this year in Poland. And I hope that the international community and the Netherlands will continue following what's going on in Poland regarding LGBT rights as well.
Thank you very much. And the questions are coming in now. I see that Kim is already replying in writing to the question by Patrick Wakowiak. There's two questions that I first want to address, I think, to Anna, which are about European arrest warrants, mutual trust, and Polish judicial independence. One is very specifically from Rob van der Hoeven to you, Anna, about whether there was any reaction from courts, but also in public and maybe in the media on the recent ploys of the Amsterdam court at one point disallowing a transfer of a Polish suspect to Poland. But Romain Lano makes that question a little bit broader and points out that in fact mutual recognition, mutual trust is a much broader issue than just with regard to European arrest warrants. And he wonders if there's so many systems that actually run on that principle, should we also do sort of a pre-rule of law test before some information gets entered into some of the systems that run on the basis of that mutual recognitions, like the Schengen information system? And I think that the first question, Anna, is for you, and this broader issue of mutual recognition and trust and the broader implications could be addressed by not only you, but also the other members of the panel.
It was very much discussed in Poland. The question of the European arrest warrants is a blow to credibility of the justice minister, who likes to position himself as a sort of like a sheriff from Westerns that would crack down on crime. And now we see the public opinion says that actually suspects or convicted people cannot be brought back to Poland to stood before the Polish court because of the so-called justice reforms that were implemented. And definitely it made a big impression, the decision of the Amsterdam court, but also the decision of the Karlsruhe court that in two cases suspended so far, not rejected, the execution of the European arrest warrant. So I think that these cases are really important, and there was, of course, a backlash from the authorities in Poland. The National Public Prosecutor instructed prosecutors to try to see if the courts in the Netherlands are independent enough to send people from Poland to the Netherlands. And there is also a couple of very curious justifications to judgment delivered by a court in Warsaw that considers European arrest warrants. And there is certainly a portrayal of the Netherlands in pro-government media that is far removed from reality, but which vilifies in a very caricatural way, sometimes even a funny way, the way of life in the Netherlands, and how the Netherlands actually protects human rights, especially the rights of parents.
And do you see any potential for this mutual recognition type of discussions to become wider in Poland, Anna, or is this really very much focused on the European arrest warrant?
I've seen that the judges from Krakow has recently held a seminar regarding the child rights and child protection cases. So perhaps it will be also in the area of family law. That is something that touches a lot of nerve in Poland because of so many Polish people emigrating abroad, forming families abroad, and those transnational family law issues are really important.
Mm-hmm. And is there an aspect to this as well in Hungary, Márta?
I'm sorry, can you repeat the question, because I was answering something in the chat.
Yeah, sure,
no
problem at all. No problem at all. Mutual multitasking. No, I mean this of course the whole fact, as Kim described in the beginning, that the whole construct of the European Union is so much based on mutual recognition and mutual trust, and that can also be that's being undermined, and some judges in the Netherlands draw consequences from that. Is that also something, an angle that is relevant in some way in Hungary, not only perhaps with European arrest warrants, but other mechanisms that work on the basis of mutual recognition?
Well, it's just my ignorance that I cannot cite you any cases specifically, but I think this is an issue that is absolutely arising on the horizon as fear. And it is something that it would be, I think, important to look into how this could be more operational. So, you know, this seems like a very sort of a nice principle, but how also with the rule of law, how can you explain this to lawyers who can then take cases, to Hungarian judges who could then potentially maybe think of questions to ask from the Court of Justice. So one of the things that we've seen that worked is something actually coming from Poland, where there was a very extremely useful practical guide on how to use in domestic procedures EU law for lawyers, how to actually bring out the EU law issues in domestic proceedings, focusing on the Fundamental Rights Charter. And I think it would be great if this kind of body of manuals of you know, guidance could be prepared also on these rule of law issues, specifically up to date with the new case law that has developed since this Polish publication is maybe about 2 years old now, which could then, you know, assist lawyers to take this. The mutual, you know, these kinds of issues come up in policy discussions. They certainly come up in political discussions, but I think in, you know, for an attorney acting in Budapest, this is not what wakes them up at night, but it should. It should.
Kim, you're nearer to the night than we are. Do you want to
yeah, stay awake at night,
yeah.
thinking about this all the time. Yeah, so I just want to add to what Márta said, which is, so here's another structural, you know, my remit is to sort of think at EU level. Here's another structural problem with the EU. The treaties say, of course, that the EU should become a signatory to the European Convention on Human Rights. And we all know what happened to that, Opinion 213 and all of that. But here's something that it seems to me the Commission misses an opportunity to use, which is that many of the domestic human rights groups in the rogue member states, actually in all member states, are taking cases to the Court of Human Rights where they win judgments that are then unenforced, right? So I'm just thinking of one that I think is really crucial in Hungary, which is the Szabó and Vichy case that went to the Court of Human Rights, in which the Court of Human Rights found that this new anti-terrorism police unit that Orbán set up, which I've called his private secret police, has unlimited surveillance powers against anyone in the country for any reason not limited by law. And that court found that this surveillance capacity violated, you know, the right to private life in the European Convention. Well, if it violates the right to private life in the European Convention, it certainly violates data protection rights under EU law. Now that judgment is what, 5 years old, 6 years old? The Hungarian government has never fixed the problem. They still have a police unit reporting directly up to the interior minister and into Orbán's cabinet that has basically turned Hungary into a police state. Every human rights defender in Hungary is under monitoring. I know when I go there, my phone is tapped. Everybody knows their communications are intercepted. What is data protection for in the EU, except to prevent the turning of states into police states? And yet the Commission has never taken note of the Szabó and Vichy judgment, which is the result of evidence and legal analysis and all of that. So here too, this is also, you know, the treaties are designed to think about closing the loop between human rights enforcement at the Court of Human Rights and the honoring of rights protected by the Charter of Fundamental Rights in the EU. And yet that gap has opened up and the Commission never takes note of the ECHR cases, thinking about how EU law might be brought to bear, right? So this is another thing that seems to me lawyers can try to do. But again, the Commission's way of ignoring the ECHR judgments, especially when they touch directly on EU law matters, is just another way in which you can see the Commission lacks political will and is not enforcing EU law.
Thank you. We have two questions from one of the Meijers Committee members, Márta and Haier, and they're both about media pluralism. One is specifically about precisely how in Poland this capture of the media, as you described it already a bit, Anna, has taken place. If you could elaborate a little bit on that. But the more general question that could be dealt with by any of you, particularly also you, Márta, is media, of course, also touches on issues of economic law, state aid. Is there never been any sort of case brought in Hungary to the Commission, and what's being done with that? Let's start with Anna.
So the current government has had this conviction for many years that the media in Poland is tilted towards liberal and left views, and that it's actually not, there is no pluralism because conservative views are not presented enough. So when it was able to take control over public television and broadcasting services, it actually fired many journalists, and those remaining have been involved in creating a real propaganda, very simplistic but very effective propaganda that does not meet any criteria of an independent, unbiased programming. But there is also a quite developed private market, private media market, which is owned to a large extent by foreign companies, German, Swiss German companies, and that also fell very well into anti-German, anti-Western Europe rhetoric of reclaiming sovereignty and putting Poland first. So now the government is actually legitimizing the takeover of local publishers, saying that, well, before it was a German publisher who had the majority stake in local press, and Axel Springer controls tabloid sector in Poland as well, which is of course very influential, especially among law and justice readers who are elderly and usually less educated and live in rural areas, to put it very simply. So the idea was to use very different means in the same fashion as in Hungary. So not changing legal architecture, but just trying to buy out media when possible. So far, we haven't seen tangible outcomes of this takeover of local media, but we see that the chairman of the Law and Justice Party, Mr. Kaczynski, sees an enormous potential in this, because it not only allowed the ruling coalition to have control over print media, 24 out of 25 local newspapers, but also on 500 online portals that can be used in the next local and general elections, which will be in 2 years and in 3 years. And Mr. Kaczynski clearly sees the potential, because he basically said that the CEO of this company, a state oil and gas company, has a gift from God, and perhaps this person will be a replacement for the current Prime Minister of Poland. So we may see if this model of buying out media succeeds, we will see shrinking media pluralism in Poland. And this is actually something that is important to discuss on a European level, given the level of ownership, of foreign ownership of media in Poland, that actually, as this is the case in Hungary, that German automotive industry supports indirectly and sometimes directly Viktor Orban's regime. And in Poland also, of course, there is freedom of freedom to sell the assets that the companies have, but perhaps there could be more discussion in Western Europe about the question of selling out media and other important assets to the government-controlled companies in Poland.
Is there so you're basically saying also here, apart from the data protection area that Kim mentioned earlier, also in the area of media pluralism, the European Union should step up. I think that in the chat, Kati Zeres already mentioned that some of the cases in Hungarian context, and maybe Márta can tell us a little bit more about it later, are already brought under the from the angle of state aid. But do you actually see, or is there any discussion in Poland about how there is a sufficiently relevant European Union law angle to tackle this, Anna?
Well, there's definitely now a discussion about state aid, that so much Polish state aid is fueled to the state broadcaster. It really creates an imbalance on media market because it provides the state propaganda with considerable resources. And of course, we haven't seen exact draft laws yet. So it's difficult to discuss what should be amended, but definitely there should be more monitoring, more focus on that, and more help to independent media organizations, which are also facing, as we mentioned in the beginning, strategic lawsuit against public participation. Just to put it into perspective, the biggest publisher of liberal news in Poland, Gazeta Wyborcza, is facing 55 lawsuits against its journalists. And Oko Press, where I work, is a small organization, and it faces 9 lawsuits. So you can see the level of legal warfare that is used to potentially silence and exercise a chilling effect on media in Poland.
Thank you. Well, at least we're glad that you're not silenced, Anna. Márta, what is the Hungarian angle here?
Yeah, so there are very similar concerns. Of course, I think they have also inspired developments, recent developments in Poland. In the chat, responding to that question, I also, and Kati Zeres has put in the links. There's 2 state aid complaints filed with the Commission. They have been at the Commission for quite a while. They're being investigated, but no infringement action has been triggered yet. The first one was, I think, in 2016. In the meantime, there is extremely accelerated regression in the field of media pluralism in Hungary, and one of the drivers of that is exactly the same as Anna pointed out, changing ownership. The other is, of course, public money going into politically directed advertising that props up certain outlets, but it also makes it very clear which are preferable, and makes it also has, of course, implicitly a chilling effect on private advertising too. So it completely distorts the media market. I think this is of great concern, and the Commission should really step on the gas pedal on this, because of the same thing happening in Poland too. Now, beyond this, of course, there are SLAPs. In Hungary, I'm not aware that this would be so widely used, but it's great that the Commission wants to come out with a anti-SLAP directive. And I think it would be really important to equip lawyers and also NGOs working on media freedom issues and beyond on what this means, and how build awareness of what SLAPs are, and also how to take action or react to that. There's a lot to do there. And the other thing is that the rule of law monitoring report does have a section on media freedom. Today is March 5, and the deadline to submit is March 8, but no one will be really writing about state media or public media unless NGOs themselves realize that they can put information into that, because the Commission is not asking too much. So it sort of misses a very strong point in the methodology of that questionnaire. And Democracy Reporting International has basically made the case that, I mean, come on, is a huge issue in Poland and Hungary. It's basically a propaganda mouthpiece that actually is spreading lies about the European Union itself, and it's slandering, it's stigmatizing Hungarian, Polish citizens themselves. So there has to be something done about it. There's a lot to do that, and actually the ball is on the Commission's court in many of these.
But if I may ask you, Márta, you didn't end up for no reason on the Politico 28 list. Strategically, would you advise us to continue beating the dead horse of framing this as a rule of law issue, or should we, if we write as a Meijers Committee analysis of media pluralism, address it to the competition commissioner, Vestager?
That's where, yes, exactly, and that's where the complaints are. So interesting, of course, that rule of law finally, after so many years, it has dawned on Europe that this is an issue. There's also, of course, other competing priority issues, but I think we have now done the groundwork, and it's there now, that the realization, but it seems to be relegated to certain DGs and certain commissioners. We don't see too much talk about this or real action at the very top of the Commission, sadly, but also if this is such a cross-cutting issue, how come it is not a concern everywhere? I remember very well when the Hungarian development started to unfold early on. One of the first issues was, of course, the media law. And the Data Protection Commissioner, as Kim will, of course, remember, we didn't even know who to write to, which commissioner. We did write to one, but then she said, oh, it's not my competence. Let me, transfer your complaint, your issue to the next one. It took about a year until it was, the place where it should have been was found. Why is it that these questions about basically siphoning taxpayer funds into political propaganda mouthpieces are not being addressed at the right place, since the dilemma or the problem has been, I think, pretty well phrased already.
Thank you. Yeah, Kim, you're already I'm sure that you want to react, but I also want to immediately give you two further questions from
go
Liz.
to new questions, sure.
So of course you're free to react to this as well. But one of the questions that was asked as well is, you have lambasted the Commission for not acting on 258. Do you expect it to have a relevant new tool in the rule of law conditionality regulation? And I'd be curious to hear your viewpoint on whether the concerted assault problem, as you put it yourself, could be addressed in a relevant way through that regulation.
Yeah, so there is this new tool in the toolkit. And those of us who've been following this for 10 years are really quite sick of the discussion of tools, right? Which is to say, infringement actions have been there from the beginning. They're still there. I still think that those are probably the most effective way to challenge enforcement of EU law, and that the whole EU law system depends on the Commission enforcing rule of law through infringements. So now there's this new possibility. It was also, I think, generated by Frans Timmermans' original letter of 4 foreign ministers, thinking, how can the EU fund these governments that are sticking their thumb in the eye of European values? So the conditionality regulation looks, if you just kind of read the headlines, like finally the EU has an instrument for enforcing EU, sort of rule of law conditionality. If member states don't follow the rule of law, then maybe their funds can be cut. Okay, so this, you have to look more closely at the regulation. And as the regulation went through the process from the Commission's original proposal to what finally came out, what you'll see is that the member states in the Council progressively narrowed the application, the applicability of this regulation, so that it's not useless, but it's very hard to apply. So the good part is that there's a very broad definition of rule of law. So what I really hope is the takeaway from that regulation is that there now is officially in EU law a definition of rule of law that is much more expansive than what the Court of Justice has even indicated till now. So I'm thinking that there isn't, so if anyone's referring to EU law in any other proceeding, here's a good definition. So it includes things like attacks on separation of powers. It includes attempts to undermine democracy. It includes, of course, undermining of the judiciary and many other things. That's the good part. The bad part about the new rule of law conditionality mechanism is that the Commission can only complain about what a member state is doing if it's doing it while spending EU funds, right? So suppose that Hungary were to decide to ban all civil sector NGOs, but it didn't use any EU funds to do it. Hard to say it falls under the regulation, even though it's hard to imagine a more direct assault on the rule of law. Because if the Hungarian government isn't spending money doing it, it doesn't fall under the regulation. So this is where the regulation is really designed to cover violations of the rule of law in EU programs for which EU money is being allocated. It might be very effective as an anti-corruption tool. I think that's ultimately where the member states were trying to push it. So if the money from EU tenders goes only to friends of the prime minister, and the accounting mechanisms that might track it have been suspended, or they're not being enforced, or the procurement process was compromised by political favoritism, that's the kind of thing that the EU, regulation clearly is designed to hit. And we know, particularly in Hungary, the EU clawed back 10% of all the money allocated under the last multi-annual financial framework because of shenanigans with public procurement in Hungary. They can clearly go after that yet again. But again, here's where the EU is big, slow-moving. It never surprises a member state. And the Hungarian government has already taken steps to avoid and evade the application of this regulation by creating a set of new legal institutions, public foundations and public trusts that can receive EU money, but that as soon as they receive EU money, it falls off the radar of national state audits. So the Hungarian government's already preparing for the EU to have no paper trail to follow when EU funds are spent under the new multi-annual financial framework. And of course, as you know, the Hungarian government tried, in using its veto, and Poland also was joining Hungary in this regard, using its veto over the budget to insist that the Commission not enforce this regulation until after the Court of Justice had had a chance to review it. Now, I've written and others have written that this is patently illegal. The European Council has no lawmaking function. It cannot tell the Commission how to not to enforce a law. It can't tell the Commission that, as the European Council conclusions did, that it has to draft new guidelines, that it has to add all kinds of things to the regulation. The European Council is putting pressure on the Commission to not enforce this regulation. And that's going to get in the way. So I think that we should press the Commission on this. It is a new tool. It can be used for some things, I think, very effectively. But again, we're still running into the black hole of lack of political will at the Commission. And this is where it seems to me that, public attention on this, a public outcry, if this rule is not enforced as written, as passed, as law, I think we need to keep our eye on the Commission. But, all of this circles back to a Commission that has really shown itself to be not so urgently concerned with rule of law. So we need to keep pressure on the Commission.
Thank you, Kim. I think that this is a time for the last round. And there was one question that was addressed to me, and I actually want to put it to all of you, which was by Romain Lanneau, whether we as a Meijers Committee project are planning to support strategic litigation with regard to the member states and EU agencies. In fact, at the moment, this is very much a kick-off brainstorm. We're very much open. We want to go where we are the most relevant. So this is something that will depend on our assessment of that relevance. I definitely do think, as was explained by Anna, particularly in Poland, the strategic litigation. This strategic litigation is now only used to undermine the rule of law in slap cases, and we might as well just counteract by trying to uphold it. So my question to you, also to end up on a high, we've heard we have a great tour d'horizon. What is it that you think that we as a Meijers Committee could concretely focus on, and who would you recommend us to work with? And I'm going to ask that to all panelists, and I'll just start with Kim and then work back to Márta and Anna.
Yeah, well, thank you. So, so first, as you can tell from my general presentation, that it would be great if the Meijers Commission would get back on this Article 259 issue as soon as the Netherlands has a new parliament. That was an extraordinary initiative. I think other member states were starting to kind of join in this call to figure out how to enforce EU law if the Commission is a black hole, and how to spur the Commission into action. So I think that that matters immensely. I think it also matters immensely that while we have states modeling how not to do the rule of law, that we have a member state like the Netherlands, which has consistently stood up for the rule of law, and in its modest Dutch way hasn't always taken full credit for it, right? So being out there as the Meijers Commission with the website, keeping track, having a kind of national monitor with an ear of the national government is, I think, going to make a tremendous difference in the visibility of this problem across Europe. So I think this is a great project, and forward with Article 259, please.
Thank you. Márta.
Yes, I think there was a lot of good recommendations already said, and I particularly like the ones about, pooling information about cases, ongoing cases. There is lots, and it's really hard to find. So I think that's great. I would repeat again the sort of handbooks or any sort of professional, legal, practical tools to assist lawyers in member states beyond Hungary and Poland also to litigate rule of law cases, to give them arguments, to help judges become aware of these angles of cases, and also to perhaps assist in making preliminary references to the Court of Justice. Now, I know, John, in a previous seminar, you've said that this only works if judges are not intimidated and they don't have to fear repercussions for making these requests to the Court of Justice, and that's certainly true. But we need trained lawyers anyway. And I think there's a lot to do there also for civil society on the ground to cooperate with this. Another thing that I would want to raise is, we didn't talk much about it, although it's extremely important, is the transparency and anti-corruption measures. So to make sure that public funds remain public and publicly accountable. One thing that has happened in Hungary is, that public becomes private, while at the same time private becomes political in a completely different way than the original statement was intended. So we have to make sure that there is robust freedom of information legislation being used. And conversely, and somebody also mentioned this in the chat, that the GDPR is used, particularly when it comes to privacy concerns. Going back to Kim raised the Sabo and Vichy case, which also had an angle, of course, about the oversight of national security services, both parliamentary and judicial oversight, and judicial permission for any form of surveillance. Now, this is not something that we normally talk about in a rule of law context, but I would suggest that we also keep an eye out on that and strengthen our not only awareness, but our actions on this front, as we do know that this needs to be something to pay attention to in any democracy, but particularly one that is breaking down and failing its citizens. It's better to also look at that. This is to see whether this is something that EU law can be brought into. The third thing that we didn't mention, and there's been calls before, which I think was extremely important, and particularly 2020 with COVID restrictions and all, makes it even more clear. We need to continue to call for the Court of Justice's hearings to be public. I mean, it's just technologically, so we're sitting here. It is possible. What is it that holds the court back? that not only for the sake of transparency, but also for domestic actors and lawyers and judges to become more familiar of what this means and how does it work in practice. So I think this is a pretty simple call, but it's certainly something not to forget. And I think it's in the interest of everyone. So with this, I'm sure there's a lot more, but I conclude here.
Thank you, Marta. And finally, Anna, last but not least.
I would say that it's important to tap into the potential of judges and prosecutors, not only in Poland, but also like on a European level. We've seen recently how the European Commission answers to the joint letter signed by more than 5,000 judges and prosecutors. That is really impressive. I was saying about the letter, not about the response, which was not very impressive. But we have recently had a seminar held by MPs with Polish prosecutors speaking. And actually, after increased harassment, the Independent Association of Prosecutors, Lex Super Omnia, received more applications from prosecutors who want to join and who are mobilized, even more mobilized than before, to fight for the rule of law and for the independent prosecution service in Poland. So I think that there is a lot of room for networking, for improvement, for better communication. The channels has been already established between different judicial associations and associations of attorneys. But if the case of judicial independence is truly a pan-European case and we can feel it, maybe the European Commission will listen, or at least listen more than it does now.
Well, thank you so much. Thank you very much indeed for all of your very inspiring insights and your engagement. We will definitely have plenty to think and talk about in the Meijers Committee in trying to give this project shape. So we are very grateful, and thank you very much for your availability here, and hopefully we'll soon be able to join the good fight in a more open way and make sure that, as I said, we continue talking law to power and make sure that that we have an impact. So thank you very much, also on behalf of everybody who participated, and I wish you a lovely day. Thank you.
Thank you very much for having us and for your work. All the best, everyone.
Yeah, absolutely. Honored to be with all of you, and the fight continues.
Bye-bye.
Great, thanks.
Bye. Shall we